Good afternoon, everyone. Welcome to the 6th session in our 2020 School Law Conference. I'm Kendra Yock, and I'm excited to welcome you here today. For those of you who have been with us for the past almost 30 years, you know that each year we have an annual School Law Conference for clients and friends. We're always excited to be in Oak Brook with hundreds of you for sessions on all the school law topics on your mind during the year. This year, we're unfortunately not able to be all together, but we're happy to use this Thursday afternoon time slot to bring you the sessions we would otherwise present at our School Law Conference. Our conference this year is going between October and December every Thursday at noon with a break for Thanksgiving. I'm excited to welcome our panel today. We have Eris Dalianis, Scott Metcalf, and Aaron Walsh. We are also thrilled to be joined by Sarah Hartwick, the Executive Director of EdRed. Good afternoon, everybody. Additionally, we wanted to give a special welcome to 3 members of our audience, Emily, Danielle, and Ansara. They're student interns from Downers Grove South High School, and we're pleased to have them with us today. Before we begin, I do want to also let you know that you can sign up for next week's School Law Conference session, which will be November 12th at 12 p.m. It's called Faith in a Pandemic, Top 10 Takeaways. This session will review the lessons learned to date related to providing special education services during remote, hybrid, and in-person learning. Registration will be sent to you after today's webinar, or you can find it on our website under Events. While you're there, don't forget to check out our many alerts, blogs, podcasts, and webinars that we've hosted over the past year and will continue to do as we all get through this difficult time. If you or any of your colleagues are not able to join us for the full presentation today, or you want to review this or other presentations, the recordings are also on the website. They're also on our YouTube channel and on our Education Law Insights podcast. So you have lots of options. Please do submit your questions today using the Q&A function in Zoom. We'll do our best to answer those questions as they come in or at the end. And as always, if you have any follow-up questions or things we are not able to get to, please reach out to any of us or any other forensic attorney. Okay, so here we are, and here's Sarah. And we will jump right in with one of the big pieces of legislation from this year, and I think Aaron's gonna get us started.
Okay, thank you, Kendra. So this past May, during the special session, the Illinois General Assembly passed a number of bills addressing important concerns for local governments and schools during the COVID-19 public health crisis. Now that special session led to the passage of the Education Omnibus Bill, which was Senate Bill 1569. And that bill addressed a number of issues previously addressed only in Governor Pritzker's executive orders, and that will apply during the tenure of COVID-19. So one of the first changes or impacts that this legislation has is that it allows tenured teachers who received an excellent rating on their most recent evaluations and whose current evaluations were not completed during the spring session to default to an excellent rating during that time, in that time period is going to cover when the governor has declared a disaster due to a public health emergency. So in this case, COVID-19. And that default is going to be in place unless the school board and the union agree to a different process in writing. Now, like the original executive order, all other tenured teachers will default to a proficient rating if their evaluations had not been completed or will not be completed during the 2020-2021 school year, provided that we're still in this public health emergency. So another change is that the legislation authorizes the use of remote and blended learning days and makes a specific reference to e-learning programs to affirm that districts may utilize and approve e-learning programs during remote learning days. Now, it's important to point out that the legislation specifically requires that districts post their remote and blended remote learning day plans on their websites. Another change that was brought about by this legislation is that it allows schools to count up to 5 remote learning planning days as part of the school term. It also suspends clock, hour, and attendance requirements when, again, the state is in a designated public health emergency. It also extends the expiration of professional education licenses by 1 year. So licenses that were set to expire on June 30th, 2020, now have until June 30th, 2021. And finally, it suspends the requirements that student-teacher candidates complete their classroom teaching experiences. Specifically for the spring 2020 semester of the 2019-2020 school year, it waives student teaching requirements for that time period. Thereafter, the legislation indicates that during the implementation of remote learning days, a candidate seeking an educator license may complete his or her teaching remotely as well. And then finally, it just affirms that districts or other third parties cannot challenge or declare a graduate's diploma or credentials invalid under these waiver and suspensions.
Great, and I'll just jump in and add that with the suspension of the clock hour requirement, that does also give to ISBE the authority to then sort of restate what that requirement is going to be during this time. And ISBE has said that they're sticking with that 5 hours for now. There's a lot of flexibility though, whether that is synchronous or asynchronous, in person or remote. It can be really flexible depending on the needs of the students and the district.
That's a great point, Kendra. Thanks for bringing that up.
So just quickly, the legislation also allowed an extension of section 17-2A of the school code. And section 17-2A allows for transfers between a school district's operating funds so that money can be shifted, for example, between the educational fund and the operations and maintenance fund and the transportation fund back and forth, and also between the tort immunity fund and the operations and maintenance fund. The purpose of this statute was really to allow a lot of additional financial flexibility for school districts. And in this particular year, school districts needed financial flexibility more than ever. This provision was set to sunset on June 30th, 2020, but the omnibus legislation extended that period by 1 year until June 30th of 2021. And I know that Sarah probably worked a little bit on trying to get that sunset provision eliminated so we wouldn't have to revisit this every year. And hopefully one day we'll be able to accomplish that goal.
Hopefully next year, absolutely, Scott.
So then additional other aspects of this legislation. And I apologize for the background noise that anyone may be hearing. There is construction going on outside my condo building, literally about 20 feet away from me. So please bear with me. So other items that are just worthy to note is that it allows remote completion of the Constitution test and the 8th grade U.S. history requirement, and it waives any sort of physical education assessment requirements. The legislation makes clear that districts are not allowed to withhold a student's report card simply because they were unable to submit proof of health, immunization, or dental examinations. And then finally, the bill codifies ISBE's graduation requirements, and it allows ISBE to adopt rules to modify the graduation requirements and validate diplomas conferred under that modified graduation plan during the pandemic. It also makes some requirements or some changes to the IEP plans with for students with disabilities, but I'm going to turn this over to Kendra, our special ed expert, to go into that in a little bit more detail.
Thanks, Erin. So as you guys are probably aware, last fall we had a handful of new procedural requirements that went into effect, and those were then slightly tweaked this summer as part of this omnibus bill. And so we'll just review some of these changes. The first, you guys know that draft IEP documents, evaluation reports, and other materials that are going to be reviewed at an IEP meeting need to be sent to parents 3 days in advance of the meeting. You remember that went into effect last fall. It was put on hold in, I think, December, and then it kicked back in July 1st. So this is something, we're all training ourselves to remember to do. I recommend whenever you schedule an IEP meeting, mark it on your calendar 3 school days in advance to make sure that those draft documents get out. A change that was put into effect in this most recent bill was that the parent gets to decide how they receive those documents. And one of the options need to be via mail or via picking it up at the actual school. Hopefully a lot of parents will opt for just getting an email during these times, but they do have that flexibility. Parents also need to be notified that they can request their students' records prior to an IEP meeting. Another one of the requirements that went into effect last fall was to keep related service logs. And there was some confusion about which services counted and were required to have this additional documentation. And so the law that went into effect this summer clarifies that those need to be kept for speech, occupational therapy, physical therapy, social work, counseling, psychology, and nursing services. So it's good to have that additional clarity. And it does change that those logs need to be provided to parents upon request. So they're a student record, just like any other student record, you provide that when the parent requests it. The prior version of the law required them to be available at an IEP meeting. That is no longer just a default requirement. Additionally, there's the notice that's required to parents if an IEP service is not initiated within 10 school days. That was clarified that it's not just sort of any 10-day gap in services, it's really when those services are initiated. I would think about, if there's a gap at another time, you may also want to provide a similar notice, but this really focuses on that initiation piece and clarifies that not only does the parent need to be informed of their right to request compensatory education, but informed of the procedures to actually do so. And then finally, there are a few changes with respect to MTSS. The prior law had required really parent participation, that they would be at the meetings when the school team was reviewing that data. And the change here is that the parent needs to be informed when their student is participating in this additional intervention and get all of the data, but there's not a requirement that they be able to attend those meetings. So it's obviously encouraged that they are part of the process. Okay, another big change, and this is obviously at this point not legislation, this is new regulations from last April. Sarah can tell us a little bit about, we have some pending legislation that may be up during the veto session, but for now let me tell you about the regulations. So they clarify, the focus is really trying to limit the use of timeout and physical restraint as much as possible. And so they've clarified when those techniques can be used, and it's only when the student's behavior presents an imminent danger of serious physical harm to the student or others, and less restrictive and intrusive measures have been tried and proven ineffective at stopping that imminent danger of serious physical harm. So that's a higher threshold than what was in place previously. There are also definitions for timeout, isolated timeout, and physical restraint. As we went through sort of the emergency regulations and then amended emergency regulations and proposed regulations and amended again, there were a lot of iterations and there was some confusion about what counts as timeout and what doesn't. And these regulations do provide a bit more clarity in that it needs to be an involuntary separation of the student from their classmates. It needs to be monitored in a non-locked setting, and it does not include interventions like taking the student to a sensory room to help them calm down, an in-school suspension, going to the principal's office for a conversation about a behavior. Those types of interventions are not timeouts, and that's really laid out much more clearly. Additionally, isolated timeout is only allowed if having that adult in the timeout room would pose an imminent danger of serious physical harm because that student is continuing to engage in extreme physical aggression are the exact words. There are also additional limitations on physical restraint. It must end immediately when the threat of imminent danger of serious harm ends, or when the student indicates an inability to breathe or staff recognize the student is in respiratory distress. So again, there's really the safety aspect of all of this too, in making sure that students are safe during these interventions. Staff do need to periodically halt the restraint to evaluate whether or not that imminent danger continues to exist. Prone and supine restraint are allowed in very limited circumstances, but that sunsets July 1st, 2021. So we want to be planning to phase those out, and Sarah, I think, can speak specifically to that too. We may need to get ready to do that sooner than that date. Additionally, it requires a review meeting if these techniques are used on 3 days within a 30-day period, which does provide some additional clarity on what the prior version of the regulations had stated. And finally, it requires 8 hours of annual training. And the subjects are specified and they are expanded from what the training previously required. Training needs to include crisis de-escalation, restorative practices, identifying signs of distress during physical restraint and timeout, trauma-informed practices, and behavior management practices. So again, really focused on that prevention piece, so we don't have to get to the use of these more restrictive interventions. There are additional topics that have to be required, including, those less restrictive interventions and how to safely implement timeout and physical restraint. And this training can be done remotely except for the actual practicing of the physical restraint piece of it. So Sarah, do you want to fill us in a little bit on what may be coming our way next?
Yes, absolutely. Thank you. And I did want to point out too, with the last slide and this slide, really showed the involvement of stakeholders and educators and our partners at Franzik in the implementation side of both of those, the bill itself, and then now ISBE rule related to timeout and physical restraint, and just showed how our legislators and ISBE are listening when it comes to implementation to address some of those concerns. And I know Kendra had referenced the pause with the legislation that passed last year with regards to notification to the parents and all the paperwork that was required to be shared. And our local legislators listened and jumped back into legislation to make some changes. And the same with timeout and physical restraint. We do expect to see legislation related to the timeout and physical strength going farther than what Kendra kind of outlined is in ISBE rule, be it veto session or lame duck session. We worked really hard to streamline some of those requirements that go beyond ISBE rule to really dig into the rationale behind it. And the intent of the legislators, the legislative sponsors who have had months-long negotiations with all the stakeholders at the table and understanding where they're coming from and where they want to go. And so we have seen a couple of drafts of the legislation. We are continuing to ask for more modifications to, again, balance the intent of the legislators with what's actually happening in the field. And so we do hope to see a final draft soon, and we will be sure to share it. But I feel I'm very fortunate on behalf of EdRed and our member districts that I think, got it to a good place. But of course, once we see the final language filed, then we'll be able to have a position on it. But again, just trying to stay close to this issue that we know is very, very important, and it did warrant some changes, and just making sure that those changes are respectful of all parties and first and foremost, above all, in the best interest of students with special needs.
Great, thank you. And I see we do have a question about if there's been any discussion about delaying the requirement to do the physical management portion of the training during the pandemic. And my understanding is that everything else can be done remotely. The physical portion needs to be in person so that you can really say that you've been trained on it and are able to implement it safely. And I would say, if your students are all remote and so nobody's going to use this technique, I'm less concerned about you meeting the December 31st deadline. I'm most concerned with when you're going to be in front of students. If there is a possibility that a staff member would need to use one of these techniques, they need to have training in all aspects within the last year. So if you have staff that may need to use these, then those staff members should have that physical training as well. So if they're going to be in front of students, then we've got to get that physical portion of the training done too. Okay, there were a lot of new curricular requirements that were passed last year and go into effect this school year. I'll just review them pretty quickly because I think everybody is aware of them. We have the section that requires that textbooks be non-discriminatory and include the contributions of all the people protected under the Illinois Human Rights Act. And that also includes teaching of the history and contributions of LGBT people. The second one is civics, which is timely right now, and that is for middle school students and having at least one semester of civics education. And that interestingly includes not just a discussion of government and current issues, but also simulations of the democratic process. So I'm sure a lot of you guys had interesting simulations and lessons during the last few weeks. Illinois history is also now a required part of teaching history in Illinois. The health curriculum needs to include mental health and illness, as well as the connection between mental health and physical health is a new requirement. The next one is with sexual education and defining the meaning of the word consent. And it's very specific as to what is and what is not consent. These ones that are in blue here are required. The ones in the green boxes are may, so these are permissive. So the geometry one is that geometry is a required course for high school. However, you do have the option to offer that as an integrated applied or career technical course that prepares the student for a career readiness path. So you have a little more flexibility there. And then the last one is the option to offer a unit instruction on workplace preparation that covers legal protections in the workplace, including protection against sexual harassment and other types of discrimination and harassment. And we're gonna let Erin tell us a little bit about some health issues that also went into effect recently.
Right, so we just wanted to highlight a few of the legislations related to the student, with a focus on student health. Now, all of this legislation had passed last August, but we felt like it was important to mention because the first two, the self-administration of medication and updates to Ashley's Law, went into effect January 1st of this year. And then the Seizure Smart School Act became effective July 1st of this year. So just going down the line, Public Act 101-205, which is the self-administration of medication, it passed in August of 2019. Now this allows students who have certain action plans, such as an asthma action plan or an individual healthcare action plan, food allergy emergency action plan, a treatment authorization form, a 504 plan, or an IEP to self-administer any medication, not just self-carry that medication as required under those plans. Now, a parent or guardian must provide written permission and as well as an authorization from the student's physician to be able to allow the student to self-medicate, as well as a prescription label for the medication. Now, districts must adopt an emergency action plan for any student who self-administers medication, and that includes a plan of action in the event the student is unable to self-administer, and in situations where the school must call 911. Now, it's important to note that the law provides immunity to schools and school employees from liability, so long as the action is in compliance with the act and does not constitute willful and wanton misconduct. So it's a higher standard than negligent conduct. With regard to the updates to Ashley's Law, while previously only a student's parent or a registered caregiver could administer medical cannabis-infused products to a qualifying student at the school, now a school nurse or a school administrator is authorized to do so. So the law makes clear that, however, prior to administering that medical cannabis product, the school nurses and or the administrators must undergo a training that was specifically developed by ISBE, and that training is an annual training. Schools may also allow the student to self-administer the medical cannabis product, but it has to be under the direction of the school nurse and or administrator, and those, whatever individual it is, must be directly supervising the student when he or she does self-administer. And finally, it allows that the cannabis medical product can be stored at the school. The last act is the Seizure Smart School Act, and that puts in place support for students with epilepsy by establishing seizure action plans, which will specify the specific services needed by the student while at school. And for those who have dealt with students with diabetes under the Care for Students with Diabetes Act, this new legislation kind of parallels those provisions. So under the act, students with epilepsy will be assigned a designated care aide. Now, schools are not required to hire additional personnel for the sole purpose of serving as that delegated care aide. However, that aide must receive specific training to the student's seizure action plan, and that training must be provided by a licensed healthcare provider with expertise specifically in epilepsy, or an epilepsy educator who has completed a program offered by the CDC. Additionally, the act requires that all school employees must receive training on the basics of seizure recognition, first aid, and emergency protocols. Now, notably, parents are responsible for sharing the healthcare provider's instructions for managing a student's epilepsy at school. And the law requires that the plan include accommodations and services that are reasonable and reflect the current best practice guidelines. The law also provides that seizure action plans will serve as the basis for students' Section 504 plan. But I want to note that while the language may suggest that a 504 plan will automatically incorporate the seizure action plan, as you all well know, a 504 eligibility and service decisions need to be made by the 504 team and on an individual basis. So for students with epilepsy who do not yet have a 504 plan, the district should follow its policies and refer the student to an evaluation. For students who already do have a 504 plan, the team will likely need to still meet to determine if revisions to the plan are necessary. Finally, the new act indicates a similar immunity provision where schools and school employees won't be held liable for care related to the student's epilepsy, so long as the actions taken are in compliance with the act and don't constitute willful and wanton misconduct.
Erin, and I see we have a couple questions here that we'll try to address. One is recommending a research to learn about each of the new state laws. And if you search on our website under thought leadership, do you have a legislative update from last year that encompasses some of these states, as well as alerts on some of the specific updates that we've talked about. Additionally, the ones related to special education and these health ones are on our special education blog, which is also linked from that same thought leadership page, so you can get additional information there. There's a question specifically about the related service logs for nursing. And yes, I would say for daily medication administration, yeah, that should absolutely be recorded as part of the student's record. Question of whether the new health laws apply to non-public schools as well. And I always have to double check because every one of these, they specify, you know, sometimes they say public, sometimes it's much broader. I think these do, but follow up with us so we can double check and make sure that's right, unless somebody else answer.
I would just also put in a plug for Sarah's website as well. I think she has some excellent resources on legislation too.
Absolutely. Okay, so a couple notable changes that went through last year, but then are going into effect either this year or coming up soon. So one is this age-appropriate policy on sexual harassment, and this, well as Title IX, there's a lot going on, so reach out to us for assistance with this piece. The second one is the minimum teacher salary, which everybody is familiar with. For this school year, it's just over $32,000, and it goes up step until it's $40,000 in 2024. The next one is the class size reporting, and that actually there's a deadline coming up November 16th, where each district needs to report to ISBE information on the total number of teachers at each school, as well as broken down by grades and subjects, the student-teacher ratios and class sizes, as well as the number of classes that exceed the recommended class sizes from the evidence-based funding law. And then the last one here adds a topic to the list of professional development opportunities for professional license renewal, and that includes training on inclusive practices and classroom strategies to improve academic and social emotional for all students in the gen ed setting. A quick overview. And another one that was passed previously but not in effect yet. Sarah, can you get us up to speed on SOPA?
Yes, thank you. And so the legislature made changes to the Student Online Personal Protection Act that go into effect of July of 2021. I was honored to be part of an hour-long webinar focused on these changes this past summer with Franzik and one of EdRed member district school administrators to discuss these changes and advise how districts can begin implementing them prior to the effective date. I believe the webinar is available, or maybe it's a podcast on Franzik's website, but I wanted to take just a couple of moments today to briefly summarize the changes for each of the respective impacted parties. So let's start with the district responsibilities. The updated provisions to SOPA included changes to school district data agreements, policy, security breaches, and even allowed for the designation of a privacy officer. The new requirements that were added to the law, honestly, a lot of districts were already doing to some extent and incorporating some of these new requirements into their current operator agreements. The most burdensome aspect of this law is that the agreements must be posted and maintained on the district's website. And additionally, that each district is required to create a policy for who can sign those contracts with the operators. The final piece, specifically for districts, is the new optional part of the law to designate a privacy officer. So each district may designate a privacy officer. The individual may be an official records custodian under the School Student Records Act. The person would be responsible to carry out duties and responsibilities of the Act. It does not need to be a new position or a separate role. And it can be achieved through just expanding some individuals' current job duties within an already existing position. And so let's just briefly go to the operator responsibility. So the changes to SOPA also impacted that related to security breach and third parties. Operators will be required to implement and maintain reasonable security procedures and practices that meet or exceed industry standards. That's in the law. They must notify the district about any breach of information within 30 days of determining that a breach occurred. And then finally, they must also provide a list of any third parties or affiliates to whom covered information is currently or has been disclosed. And this list needs to be updated at the beginning of each fiscal year, as well as at the beginning of the calendar year. And then finally, related to student and parent rights, specifically for the information that is collected and shared, and this new ability to allow for the inspection of student information. So new to SOPA is that parents and students have specific rights related to the information that's collected and shared. And again, the parents have the right to inspect that information and even have the ability to make factual corrections of inaccuracies if it's discovered within the student's covered information. So that's probably the quickest summary of SOPA. And again, as Scott mentioned, we do have EdRed worked really hard on this bill a couple of years ago, and we do have resources on our website that summarize it in addition to the resources that we've worked on in partnership with Franzik.
Thank you, Sarah. And additionally, we at Franzik have worked on some modifications to the press policy that we think make it a little bit clearer and easier to follow if you're interested in those, as well as model contract language when you're negotiating with these operators, and just some ideas and procedures for making sure that you are ready to be in compliance when this goes into effect next year. So please reach out if you have questions on those. Okay, and another enormous one, if you are at all familiar with Title IX and the updated regulations, you know we do trainings on these that last 3 and 4 hours and are quite extensive, and so I'm just going to give a really high-level overview. The new regulations were issued in May and became effective in August. They do have a new definition of sexual harassment that is very specifically defined to be quid pro quo that's initiated by an employee. The VAWA Big Four, and VAWA is the Violence Against Women Act. Title IX regulations sort of incorporate by reference these definitions in the Clery Act and in VAWA, and those are for sexual assault, stalking, domestic violence, and dating violence. And so those would all qualify as sexual harassment under Title IX. And then finally, hostile environment. And hostile environment is sort of that bigger umbrella category for other types of conduct. And specifically, it's defined as unwelcome conduct based on sex that a reasonable person would find so severe, pervasive, and objectively offensive that it effectively denies the person equal access to the program or activity. This is a more narrow definition than what you may have been operating under previously, or what would be considered sexual harassment under maybe Title VII, the Illinois Human Rights Act, in your district policies. So it's important to be able to distinguish between what's sexual harassment under those laws and policies versus what qualifies as sexual harassment under Title IX. And the reason is that under Title IX, there are very specific requirements as far as how you conduct the investigation, what kind of notice is required, and how you get to a determination. So we want to make sure that if you have conduct, alleged conduct that meets the definition of sexual harassment under IX, we are using these procedures. But if the conduct doesn't fall within that definition, that you are using your other policies in order to address that type of misconduct. Another important piece to note here is that for K-12 schools, you are deemed to have notice of sexual misconduct and an obligation to respond if the misconduct is reported to or observed by any employee in the district. So that's really broad, and we do recommend that there's training across the board so people understand their responsibilities under these new regulations. Additionally, there is very extensive training required for your Title IX coordinator, as well as Title IX team, which would include your investigators, informal resolution facilitators, and decision makers. One more thing I will flag before I move on, because I know we have a lot to cover, is just to make sure that your website has been updated to identify your Title IX coordinator, their contact information, and your grievance process. So double check that you have that. And again, if you have questions on this, we have very extensive training available. We have a toolkit available that really walks you through this process. So please reach out if you do have questions on that. And now we're going to move on and talk a little bit about some labor and employment issues. I think Scott's going to get us started.
Yeah, like they said on Monty Python, and now for something completely different. There was a bill that was not included in our legislative summary last October. And normally every September or October, we put out an alert that lists all of the bills that are going to affect our school district clients. This year, because of COVID and the shortened and abbreviated legislative session, it just wasn't feasible for us to get that list out. But Public Act 101-620 missed the list last year because it was not signed into law by Governor Pritzker until December 20th of 2019. And there is an excellent alert on our website that summarizes all of the detailed points that are contained in this legislation. And that alert was written by Jennifer Dunn and Melissa Sabota, who are two of our outstanding labor attorneys at the firm. High-level overview of this is basically that this was union-friendly legislation that was adopted after the US Supreme Court issued its decision in the Janus case. And the intent was basically to maintain union membership and limit employees' ability to opt out of paying dues. In speaking with Jennifer about this, I think it's safe to say that our experience has been that this legislation has not really changed the way that school districts interact with the unions. and everything is going along pretty much business as usual when it comes to the relationship with unions. It just may be that there are heightened requirements for school districts to turn over information and what format that information takes. But that's basically the quick summary of this act. So I'm sorry, I don't know who's next. Otherwise, I would have it's Eris. Eris is next.
Well, hello, everybody. Eris Dalianis here. Two things I want to talk about that are sort of COVID related in the property tax area. First is you probably noticed, even wherever you live, Cook County, Lake, DuPage, elsewhere, that the various county boards were trying to be responsive to the economic hardship that many taxpayers were feeling this summer and probably continue to feel with respect to making their first and second installments. So different counties implemented different solutions. So for example, in DuPage County, they allowed for a deferment of interest and penalties on the first installment if you applied and you met certain criteria. In Cook, they deferred on the second installment by 60 days and it was available to everybody, no application. So the General Assembly approved a law, it's Public Act 101-635, that effectively codifies some of this. It does not apply in Cook County. Cook County Board sort of took a different path on this, but it allows for a waiver of up to 120 days of penalty and interest. And it's not an insignificant interest amount. It's 1.5% per month, 18% a year, plus the treasurer layers on some costs as well. So it adds up pretty quickly, but it allows for a deferment and a waiver if you pay on time, whatever the extended due date is, for up to 120 days to COVID-19 relief. It's applicable for this year only, so that's what's interesting. Whether there'll be some change and make it applicable next year as well, you know, unless things change dramatically, I would imagine a lot of commercial and industrial and retail taxpayers are going to be having some hardship. Indeed, many homeowners as well. We'll see what county boards do. But that's the first thing I wanted to talk about. The other thing is a moratorium on residential evictions. So a couple months ago, the Centers for Disease Control, sort of an unlikely entity to wade into the waters of real estate and eviction law, but they approved a moratorium on halting residential evictions until December 31 of this year, so through the end of the year. The goal there was to stop or reduce the spread of COVID-19 with the assumption that if people were kicked out of their apartments, they would then go either live with family or become homeless. And the goal is to mitigate the risk of that happening. That's good through the end of the year. City of Chicago also has a moratorium on residential evictions. That is valid so long as the governor's executive orders are in place, which they are. So those are two things that are out there. I wouldn't be surprised if we see an extension on the moratorium on residential evictions, either from the CDC or the city or other jurisdictions. And then I wouldn't be surprised if we see some talk come springtime when the March 1st installment is due, or June 1 when the first installment is due outside of Cook, to give people a break and sort of kick the can down the road a little bit on these tax installment payments.
So I think, you know, we also want to look a little bit forward into what will happen in a spring 2021 legislative session, if there is one. And if there is one, will the General Assembly just do an abbreviated session or jump right in and do the full panoply of legislative actions that they normally do? If it's the last item and there's a full-fledged legislative session, the Illinois State Bar Association does have a couple of property tax initiatives that we understand that they will be pushing for. One is to allow townhomes and homeowners associations to file a single joint appeal with the Illinois Property Tax Appeal Board. Condo associations already have the ability to do this. And what we see is that when you allow people to do this, it leads to much larger single complaints. So rather than getting a bunch of very small PTAB appeals from a homeowners association, you'll get one single large one where it makes more economic sense to intervene and defend the school district's revenue base. And then the second one is to amend the property tax code to allow discovering of assessing officials' practices and procedures and methodologies. The reason for this, just in a nutshell, and we could spend perhaps an entire hour on this topic, but I will not do that to everyone. The basic reason is that a recent Seventh Circuit decision found that Illinois law did not provide a plain, speedy, and efficient remedy for property owners, and therefore it opened the door to the federal court system. Interestingly enough, the opinion was authored by Amy Coney Barrett when she was still on the Seventh Circuit, and the case has been appealed now to the US Supreme Court, and we were lucky enough to draft an amicus brief in favor of the appeal on behalf of the Illinois Association of School Boards and the Illinois Association of School Business Officials. But if this legislation goes through, it will solve the problem that was identified by the Seventh Circuit, and again, effectively close the door to federal courts for people seeking property tax refunds. So that's what we see on the horizon. But there, just to double back a little bit, I think Eris is also going to mention one change that's already been implemented regarding bidding statutes.
Yeah, and Scott, I want to add one other thing on AF More in addition to the two associations you mentioned. The amicus brief that we filed was on behalf of a number of area school districts that are affected by the plaintiffs in the AF More case, where they're facing multi-million-dollar refunds. So those were additional friends of the court or amicus curiae as well. And so, one thing we learned with COVID is that it's hard for everybody to get together and do things that you're used to doing in person. Putting learning aside, one of those things is opening bids. So historically, the school code section 10-20.21 has allowed for electronic submission, opening, and acceptance, with the exception of construction contracts. So Public Act 101-632 added this provision that now allows construction contracts to be communicated out to potential bidders, accepted, and opened electronically. There is a protocol if that's the way you're going to go. It has to be using a secure database with individual user logins and passwords, all set forth in the school code. But we had a number of clients that were running into these hurdles where they had put bids out pre-COVID, and then the openings and acceptances were once COVID kicked in. And we were able to address that issue in other ways, but this legislation makes it official, which is a good development, we think.
And Eris, I see we just got a question about how much PTAB and Circuit Court is backed up due to COVID-19. And I'll just mention real quickly that the reason I'm wearing a coat and tie is because I have to actually do a court hearing via Zoom on tax matters at 1 o'clock. So it's interesting that courts are sometimes the last institutions to adapt to changing realities. But COVID has forced them to adopt technology to keep the circuit court tax appeals moving along. And I'll let Eris maybe address how PTAB is handling it.
Yeah, PTAB, I'd say, is still sort of in the learning stages in terms of using remote technology. Scott is right. I have been very impressed by what the circuit courts have done, that I've been in front of Will, Lake, Cook, DuPage, using Zoom, having statuses, moving the ball forward. So justice is served and matters can be resolved. At this point, PTAB has not implemented any of that technology. They've basically not had a hearing since March. We had hearings set for April, May, June. All of them were postponed. They have set a couple for the end of this month. What they're doing is any Cook County hearing, rather than being at the Thompson Center where they normally are being set for Des Plaines, they've set up a protocol out there that supposedly will be safe for everybody. And then for the other 101 counties in Illinois, they're setting everything in Springfield, which obviously puts a lot of pressure on taxpayers, interveners, boards of review to settle the cases, because it would be, in many cases, a very different dynamic from a cost-benefit perspective to have to go to Springfield, bring your witnesses, anyone else is going to testify, and spend several days there. So that's what they're doing. And I think technology has yet to be fully adopted by PTAB. Hopefully they'll do it though. I think there's a way to do it to provide a fair forum for all involved and get things moving again.
So thank you, Eris and Scott, for the property tax review. And it's really interesting to think just a year ago, EdRed was in the middle of testifying before the majority of the subcommittees of the Property Tax Relief Task Force, that giant task force that was created by the General Assembly, aimed to make changes to property taxes. And EdRed's role in partnership with Franzik was really to testify and be engaged to inform and educate the legislators on what any changes to property taxes would have, specifically on EdRed member districts, but for districts across the entire state. So I wanted to start, and for those who are not familiar with EdRed, that we are a solution-oriented advocacy organization that represents over 80 school districts, public school districts in Cook and Lake counties. We work to advocate on behalf of our member districts, and that work really starts with our ad hoc committee structure. In 2020, well, prior to COVID, we had many successes as a result of our ad hoc committee work from last year. And again, that really started with our finance ad hoc committee and our partners at Franzik to be involved in those property tax relief task force hearings, which ultimately did not end up with any official recommendation that were to be implemented into law. It is unclear what the next steps for that task force is. And as Scott had mentioned, it's unclear what spring session will look like, which I'll get to in a moment. Our other ad hoc committee from last year that we hope to continue the momentum into next session is our mandates ad hoc committee. And the members of our committee and the work of our committee gave us the ability to approach this unfunded mandates conversation differently in Springfield, and was led by one of EdRed local legislators, Senator Ron Villivalam. And while again, this work was cut short due to COVID, we're looking forward to continuing the momentum in partnership with the management organizations and both teacher unions, as it started with a meeting held by Senator Ron Villivalam and all the education stakeholders around the table saying, how can we do this differently? So just last month, EdRed announced our ad hoc committees for this year. And again, we typically work in the fall to research topics that we anticipate will be taken up during the next legislative session. And for this year, we are focusing on equity and transportation. So our equity committee work began really in August, and we're looking forward to wrapping up next month and having some official recommendations on past pieces of legislation that arguably could address the equity gap and really equalize the opportunity and access for students of color across the entire state. With regards to our transportation ad hoc committee, what started as an individual member district initiative turned into the realization of the need for specifically during COVID for schools to be able to transport students to and from school using multifunction school activity buses. We learned that there are additional barriers beyond just that limited situation. We're working closely with another great EdRed local legislator to file and move legislation during veto session, specifically related to the MFSAB transportation issue, and then want to work in the spring to maybe remove some of those additional barriers that exist for school districts when it comes to transporting students that exist within the school code and in the vehicle code. So on the next slide, I want to speak to what the General Assembly has been focused on over the last really 3-4 months. Actually 6 months, and that's the Legislative Black Caucus's 4 pillars. So through the Senate standing committees, the Black Caucus has hosted subject matter hearings to discuss legislative solutions within each of the 4 pillars that you see on the slide. And while we haven't yet seen any official drafts of legislation related to these solutions, we can expect them to be taken up whenever the General Assembly returns. Just briefly to summarize the conversations that have been held at these hearings, 2 of the pillars, education, workforce development, and healthcare and human services, those members have come to similar conclusions around the need to improve the way current grant dollars are distributed to poverty-stricken Black communities. Again, we expect to see legislation filed, possibly requiring agencies to just do a better job of analyzing data and coordinating distribution of grant funds and those efforts between federal, state, and advocacy agencies. Under the criminal justice reform and violence pillar, it also includes police accountability, and we anticipate seeing legislation that will effectively end the use of chokeholds, revise how and when deadly force is used, and even an extension of police officer training. And the final pillar, the economic access, equity, and opportunity pillar, we expect legislation to address issues related to affordable housing, land use, entrepreneurship, business development, banking, and environmental justice. And again, that's just a summary of what we have observed and seen reported to come out of the subject matter hearings over the last couple of months. We haven't yet seen any legislation. And when we go to the next slide, we'll see we don't even really know what veto session is going to look like. So now that the election has passed and veto session is supposed to start in just 2 weeks, it still remains unclear if the General Assembly is going to return. There are a lot of variables that the 4 leaders are weighing, and that includes increased COVID cases, not only across the state, but specifically in the capital city. And Ed Red's focus is that whatever veto session will look like, we are going to watch for legislation potentially related to the impact of the failure of the passage of the progressive income tax ballot question. We remain concerned about cash flow issues and the timeliness of payments to schools through the evidence-based funding formula, mandated categoricals, and other grant lines. When it comes to General Assembly priorities, if veto session happens, is we expect to see an amendment to the FY21 budget. And I want to remind everyone that this year's budget assumed the passage of the progressive income tax, as well as an influx of federal stimulus dollars that have not been received. So those are items that are going to need to be resolved. We also are still waiting, as I mentioned, on the Black Caucus legislative package. And specifically for schools, it was mentioned the final version of the seclusion and restraint legislation. And there's also been conversations about this bill that has been around for over 10 years, restart negotiation, has to do with student rights, specifically for students and youths who are parents, expectant parents, or victims of gender-based violence. So on the next slide, if veto session doesn't happen, what's next? I think everyone is familiar with lame duck session, but just as a refresher, it takes place after an election, after the first of the year, but before the new General Assembly is sworn in. There's a number of issues that can be taken up because you only need a simple majority for any piece of legislation that has an immediate effective date. Bills with an immediate effective date, like the budget, if it were to be voted on during veto session, it would need that 3/5. So one question, again, related to what will the state be forced to do in terms of revenue for this fiscal year and in future years? It was assumed that the General Assembly would be forced to return for a vote, and even I think the governor has made comments publicly to increase the flat tax rate. However, given how poorly the progressive tax ballot question fared in the last, just 2 days ago, it seems it's yet to be seen of whether or not there will be an appetite for legislators to then return to Springfield and vote for an increase for those communities that voted down the progressive income tax. It's safe to assume that whatever spring session looks like, that it will probably be another condensed session timeline as we saw in May if the COVID cases continue as they have been over the last couple of weeks. This means that there will be a short list of priorities that need to be passed without much opposition, which is both good and bad for EdRed. We assume that the #1 priority is going to be next year's state budget, and we can also expect another ISBE omnibus bill related to some additional COVID changes that have been made via rule and policy over the last 6 months. And I just want everyone to know too that EdRed team, along with our partners at Franzic, will continue to monitor the legislative activity and advocate for the needs of our member districts.
All right, thank you so much, Sarah, and thank you to everybody who joined us this afternoon. Reminder, you'll be getting an email, which will have a link to the recording, and check out our website for other updates and information that you'll hopefully find useful. Everybody have a good afternoon.